right, it's another exciting adventure of Knowing the Law, Law and Lawyering Unplugged. I'm Brian Parker. My website, as you know, is collectionstopper.com. Try not to rub my hands so much. Someone commented on that. Sorry. Podcast Plus is where you will find everything you need to do the job of protecting yourself and litigating a case. Let's get to it. Today's exciting video, again, this is being given for the information and educational aspect of doing whatever it is you're doing. You do you. I'm not going to tell you what to do or advise you, but offer 30 years, hopefully less than 30 minutes. Today's video is discovery requests and motions to compel. Before you go, hear me out. I can kind of make this exciting today if you understand where I am coming from when I do these things. So I've counseled in the past, keep it simple, stupid. And also, you're always arguing and trying your case from day one. You've seen at least 7 videos. If you want to look at one of them, how to create a killer counter affidavit, or the importance of ASS, account stated counter affidavit. I've focused heavily on that, and I want you to think about that in today's video. Keep it simple, stupid. Always always argue your case as much as you can. And I'm going to show you in the middle of this how the mistakes of the other side, the other attorney, trying to make short-term gains and make billables, will actually, you can turn that around on them and settle the case. So discovery is your attempt to discover what the other side's case is about. And frankly, in debt collection lawsuits, you already know. They put their best foot forward, and it ain't pretty. But you, as I counseled, take advantage of them to defend yourself using their documents. It's as simple as that. And I want you to remember the first, before we get into this, 5 things. You cannot have the word question without spelling the word quest. So question and quest. What is my quest? My quest is to win this case based on a counter affidavit that shows how they've fallen down on their attempts and deficits, showing a burden of proof, which they generally never have. And this, among many of my 40 videos, helps you in that quest. So a quest is a goal. So remember, if you ask a question, what is your quest? What is your goal behind that question? Number 2, don't defend a hill you're not prepared to die upon. I don't want you to die. Certainly, maybe die sleeping from my videos. But don't defend a hill you're not prepared to die on. Make sure the question you ask, you keep in mind that that's going to be a question you're probably going to have to defend or enforce. So limit your questions to important questions having to do with your theme, and we'll get into that. Remember, the concept of discovery is really a small trial. You've never heard anybody say that before, but in these cases, in most cases, especially today, where the other side is more concerned about fees and billables than the truth, and that, again, is my opinion, they will create situations where you're going to have to go in and do a motion to compel. You also, they may rightfully be saying, I don't know what he's asking, or they know what you're asking and they're putting up a wall, all right? So there's a couple of reasons why they do that. In my opinion, it's mostly billables. So get used to the concept of a discovery trial. You're going to need a theme that is your quest and the reason behind your questions in your discovery, and then be prepared to die on that hill because it's important to you. And then the trial is what's called a motion to compel. So the name of the video today obviously is discovery requests and motions to compel. Can't have one without the other. So you also have to remember that most attorneys start a trial. And so the case is done. You've litigated the case, and maybe it's 9 months later. So it used to be, and I used to do this. Okay, what's my theme going to be that I got to sell the trier of fact on, which is either the judge or the jury? That's wrong thinking. The theme should be created day one. In what form? Your counter affidavit. Again, see all my videos on creating that and the importance of it. Also, you'll recall also in my review of Solo Suit, offering their services for creating an answer, fail to tell at least Michigan residents that you have to have a counter affidavit if the other side has got an affidavit, because you automatically lose your case under the account stated statute. So what is your theme? Is it inside your counter affidavit? And if you want to think of a couple of quick words, theme and meme. Theme and meme. I don't think it's wrong of you to create a meme saying exactly what your theme is. It could be no assignments, no proof, no case. Create your meme, but do it day one. Don't wait for the trial. And it's going to save you a lot of time and energy. If you have created a good counter affidavit, which tells the court, as you know from my videos, exactly why you should not have to pay this debt, why the other side has not met their burden of proof, and also that little secret thing that you can't tell anybody about, where you actually say that they have not done appropriate things, if you will, and they owe you money. And if they don't respond to that in 10 days, the way I read the statute is you win that part of your counterclaim. So theme and meme, but do it on day one. Written discovery, first tip. Written discovery is really your deposition in writing. The questions you ask at the deposition are the questions you're going to ask in your deposition. And if you want to look at it like this, you're asking about the responses of the other side to your questions. And those questions, again, are based upon the counter affidavit. So that counter affidavit comes through in a lot of ways, and I try to stress to you the importance. Whether your state requires it the way Michigan does, which is really detailed, or for example, again, I've talked about Florida, where it says just give us an objection and why. There's 3 reasons. But there are different ways to approach that, either better than Michigan, better being more intrusive, or, if you will, Florida's approach, which is just give us an objection without any real leadership of a statute saying why, like I just told you that secret thing you put in your counter affidavit. So tell the court in your questions, because remember we're talking about the mini trial that will end in a discovery motion to compel, why their paperwork sucks and how they haven't proven their case. Why? Because if you remember, and you probably won't, but from day one, always be arguing your case. And that's going to be a good theme about what I told you about look for as far as when a law firm is inappropriately answering your discovery badly. And you can turn it around on them to your benefit. Always be arguing your case. Always be winning your case. And eventually those questions, your responses to their objections, will end up in a mini trial in front of the court. Don't be taken aback by the word trial. I'm just identifying what a motion to compel is so that you adopt the concept that each stages of a case have mini trials. We've talked about summary judgments and summary disposition motions in another video. I'll point to that. That's a mini trial. The statute, at least in Michigan, references the word trial. So there are mini trials to be had, so take them that seriously. And with a trial is the end of the case. So if you treat it like a trial and you win that trial, could be the end of the case. So don't be taken aback by the word trial. The tip number 2 on discovery is based upon what your response is to their paperwork. For example, I did a piece of discovery where I asked him to explain a chain of title, which they couldn't. I already knew they couldn't. Again, that's another theme of trials. Don't ask questions you don't already know the answers to. A lot of times you're asking questions in discovery, you know their stuff is bad. You kind of know what they're going to answer. And if they answer evasively, that's a reason to emotion compel. If they're honest, that's a reason to get the case over with. They'll just call you and go, look, what are we doing with this? Let's just settle. Or they may not be they will be truth challenged. Let's put it that way. Your requests are likely to appear in court in a motion to compel. So make those requests hills, Hills, that you are prepared to die upon. Don't be bringing BS questions and then say to the judge, hey, it's really important that I have this. In front of a judge, you want to be quick and concise and to the point, no matter what reason you're in front of a judge. So having a point, having a quest behind your question supports why you're bothering him to do his job. Here's a good thing. And this is in that realm I was telling you about how you can turn things around on a litigator that you're opposing that's just being, let's say, sort of a jerk and filing responses and objections that aren't appropriate. How discovery requests or depositions are responded to are in the form of objections. And that's all right. You're going to see a lot of it. That's just more reasons that you have to show how evasive or non-answering the other side is, which is the general standard when you file a motion to compel. You present to the court, and I'll show you how to do that, why you should be granted a motion to compel. And I'll put motions to compel, maybe a couple of orders, letters I've written that support motions to compel, and also discovery requests. I'll put it all in Word. If you want to use it, that's up to you. I'm not telling you how to use it or when to use it. I'm not your attorney. But thirdly, as I said, the third tip, it's another chance for you to sell your case. A pretrial is a chance for you to sell your case. A motion to compel is a chance for you to continue that theme and meme. By the way, I've actually done this in a motion once. A guy was not answering my questions, and he was schooled, very good, purposely working around so he doesn't have to answer the answers which would kill his client. So I did a motion, and right on this first page, so I've got my motion and my brief, but on the first page, the very thing that everybody picks up, I put a picture of him doing the most goofiest thing, like it was a picture from college. I think he was beer bonging. And I was presenting to the court without actually saying it. Don't take this guy seriously. Judge, by the way, yelled at me for that. Everybody just yelled at me for that. But sometimes you make a point, and I made my point in that case. It was 10 years later that this guy is now answering questions. He's a different person, obviously. But what the heck? I'm not going to breach any rules of conduct or anything like that. I'm saying this, you know what? It wasn't 10 years. It was like 5 years. And I thought that was rather weird that the corporation was aware of his Facebook picture. And he also made some really unwoke comments, which somehow found their way, because I thought a measure of the man is, I'm saying he's not being truthful, or here's his character. So that's an extreme example. You don't want to probably get into that. But I felt that was necessary and appropriate and relevant because credibility is an issue on people and also how evidence comes in. It's all about credibility. There is this splitting of credibility. Now I'm really going in the weeds. Is it admissible? Is it credible? That's another video. But he was not credible. I knew his essence, but it wasn't coming through, so I needed the court to know who they were dealing with. So I put the meme, right? I did a meme. I didn't even realize I was doing a meme. I did a meme in the motion. You might want to consider that. Don't be me. So your counter affidavit is everything. Your meme and theme is everything. If you want to put a picture, or what you should do, is put words, your theme. Your Honor, this is about my theme. In fact, it's good that it's a meme because you do not want to put half a paragraph. And now the judge is, what? So get it in meme form because we live in an ADHD world. By the way, I am so focused. So theme and meme it, man. Fourth tip. The content of your discovery, and you'll see that the theme in my tips should be what you really need. Fact specific as to how much you ask for. Less is more. Don't ask for 35 questions and things that you want. You'll get lost. Be specific. Have a hill you're prepared to die upon. Then you will feel comfortable arguing why you need this particular document or question answered. If the judge is going through number 17, number 35, you're going to lose he or she. Be specific. You can guarantee you're going to file a motion to compel in these cases with discovery. It's at its bare minimum looked upon as a moneymaker by the other side, at a maximum protecting their client. In between there is really what's going on. A lot of the times, if you file very few requests for discovery or responses to discovery or requests for documents, that will be refreshing to a court because they can, just like you and I, okay, let me see what's my to-do list. And if they see motion to compel, like, ugh. But if they see your motion compared to most others, it's quick and to the point, they will like you for that. And you should like yourself because it's an easier way to make a point rather than being lost in a morass of words and phrases, and just get right to the point. Again, that theme is going to run, and again, my usual thing, I'm going through my show notes, which are on Podcast Plus on collectionstopper.com, so you don't have to look at this face again if you want to just learn what I just said and keep referring to something. Again, focus on the hill you wish to die upon. I keep saying that because that's what I've counseled. If you want someone to remember something, you've got to keep repeating it. And my point again is be secure and safe in what you're asking for. Bonehead litigators. Let's talk about my fifth tip. Bonehead litigators. Here's why bonehead litigators are boneheads. Sometimes you'll get a litigator that will just fight you on everything. Their short-term gain is knowing either that you're just going to go away, they may be testing you, or they get to do a bunch of fees, especially if you fight them on it. So maybe they don't answer quite the way they want to. Now there's stuff going back and forth. They're billing. They're billing. There's attorneys I deal with that call up just to fight with me. And this used to go on, and so like an idiot, I'd go, oh yeah, but it was like a bad relationship. You got hooked in, there's this one small issue, just like a bad relationship. And now you're fighting about something totally different. So and she still does it today. And I kind of like her still, not the relationship, but the litigator. And why is she calling me up and fighting? And you'd see these long threads and I go, she's low on her quota for the monthly billings, so she can bill every time. So she purposely poke the bear. I go, wait a minute. So now, and it's really hard to do in relationships, and it's really hard to do in litigation. walk away. And therapists counsel you on that, and I think it works in the law. If you see there's some kind of discord between the two of you, and either you or she started it, or your partner started it, walk away. You formulate your response, it's cleaner and more concise, and you're unlikely to go start fights that emanate off just this one issue because you left the toilet seat up or something. And now you're arguing about why this relationship should go on any further. Just walk away. So I make that point. A lot of stuff that's done by bonehead litigators is to make you fight, to make you file motions so they can bill. Also, if the case is not going well for them, that's an opportunity using your stuff to say, hey, look, do you really want to pay me all this stuff because of what Parker's asking? They may want to get out of the case. So they're not such boneheads, but it's bonehead not to just get the case settled and not wait for me to have a reason if they're so good at what they do. So whatever. Shape their responses. So that's a part of tip 5. Shape their responses. What do I mean? If you ask clear and concise questions on hills you want to die on, their responses will tell you more information than if you ask a very general question. I'll give you an example of that. You ask a question, asking for all people that have contact with the case or collection efforts of XYZ discovery. That's them going to say yes, no, here's 6 guys, and here's a lady in marketing, and blah, 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 blah. In a sense, what you're asking is what a lot of litigators do to me. It's called shotgun discovery. Well, sometimes you use a shotgun, and it's good for home invasion because you're more likely to hit somebody, especially at dark, especially at night, and you're all nervous and stuff. You want to do 22 discovery, meaning more concise to the point. So you would ask, instead of asking all the people, you'd ask name of the person with personal knowledge of each bill of sale or assignment that was created. And a lot of the stuff that you're facing from a debt buyer is up to 10 years old, So it's hard to find a person. Well, that's good for you too. And then when they find a person, because you only asked for one person, you now have forced them to stick their neck out under the rules of discovery and evidence to show that this guy is qualified, has personal knowledge, also meets the state statute bringing in certain evidence that was old and the people that created this document no longer exist or can be contacted. So that guy or gal has got to be swearing under oath about specific stuff because you just asked for one person as opposed to a whole bunch of people that they can hide their information behind. So if you ask specifically using a 22 approach, you open them up to more places to shoot them with. That won't happen with general questions. Sure, you could probably blast a couple of people away with a shotgun, but you're going to miss people. And it's not going to be fatal. And you're trying to knock stuff out. So, okay, so you've done all you're supposed to do. You've provided concise requests. By the way, there's 3 forms of discovery, and there's why I'm telling you this. Interrogatories, requests to produce. Interrogatories are asking questions. Question to produce are asking for documents that support your case or something you did or somebody else did and it's involving you. Number 3, a request to admit. I don't think requests to admit are useful because you can object. The court rules are really cutting down on this, but a person responding to request to admit can cut down how they answer. It's supposed to be it's only used for one reason, I think, request to admit. If you don't respond to a request to admit in whatever the statutory days are, it's usually 28 in state, 30 in federal court, generally, and you're in state court. In spite of what Solo Suit says, none of these rules are based on federal rules. you are going to have a certain amount of days. If you miss out responding within those days, what you were asked or what you ask of the other side after the 28 days that become non-responsive, sorry. Those questions are automatically true. That's the punishment of a request to omit. That's really the only reason people use request to omit, in hoping that you don't answer in time. Let's say you do answer in 35 days. You could still get away with that, even though it's 5 or 7 days after when you were supposed to answer, because unless they've objected and said, whoops, you missed it, and we're filing a motion, jumping in there, there's some argument that, there's 2 arguments, that you got in under the wire. Most case law I've seen says you've got 28 days, answering it without their objection, you still miss the 28 days. Your punishment is you have to omit everything. So if you're in this and suddenly they send you a bunch of requests to omit, most of which are just boneheaded, but applicable, that's why they're doing that. If you're not represented, they figure you'll just, and I've seen it tons of times, you'll not meet the 28-day rule. You'll just take your time because that you don't understand the importance. So be alert, stay legally alive to the request to omit. But generally I don't do request to omits. They're just the utility of it. There's nothing of value. If I'm sending it to an attorney, he or she's going to get to it within the time limit, and the responses aren't worth anything. So, as I said, get that person specifically with personal knowledge. That's going to be the horse they're riding on to beat you. Now you know who to focus on and how to knock them down. So your motion to compel, examples of motion to compels are on my website at collectionstopper.com, podcast plus. Once you have their responses, they're going to be BS. Tear the pages apart and circle what you really want to die on, the hill you want to die on. You've done a good job 22 in these bad boys, but think about what you want. And then once you have those circled, put those specific requests and the reason why the other side didn't answer, either violating the court rules, which you should cite, and how they didn't respond to what you were asking, and here's why. They'll give you all you need to say that. And put it in a letter. Don't just file a motion to compel. Send it to the other side, give them a hard, fast day, 5 days, and then on the 6th day, file your motion to compel. Judges will appreciate that. That letter will be Exhibit 1. They're not going to... They'll respond when you file the motion to compel, which is a BS move. Like, okay, we're going to give you this, we're going to give you this. Because they were just making you work so that they can get billables and they can also make you work. Go forward with your motion unless you have exact, specific responses to your motion's questions. Don't reward them because you fear being in front of a judge. You can't do that. A real quick tip from the Army. I was in the Army and I made it and it was really serious. I was in a discipline or an MOS, a job where you could not drop out. You couldn't be weak. They were weeding the weak ones out. So I made it my mission to don't give the prick the satisfaction, is what I said to myself. I never let them force me out of a run, force me out of some stuff. I did not want to get weeded out. I felt like if I did, I would give the prick the satisfaction. Well, I took that into litigation. So I will not give the other side the satisfaction of messing with me. I'll just say messing. I don't want you to do that either. That will settle your case for you because they do not respect you if you are not represented. I'm just telling you the way it is. And there's someone always pushing you to see what you're about your mettle, how strong you are. So go forward with this unless you get complete compliance to what you're looking for. That motion will save you. I'd rather be in front of a judge than accede and look weak on the other side because it's not good for my client. It's not good for the 5 cases I have with that person down the road. They're going to know, oh, this guy, just push him a little and no, I won't give the prick the satisfaction. So the court will love you if you've got Exhibit 1. Here's a letter I sent, Your Honor. I tried to work this out not to waste your time, Your Honor. Court will love that and may give you fees and costs as punishment on the other side, especially if their answers are really BS. So go to Podcast Plus and you'll see form letters, how I do it. You can do it or do it your own way, but those Exhibit 1. And again, your questions started day 1 with your theme and your meme coming out of the counter affidavit. I'm going to wrap this up. Lawyers don't generally think ahead. And here's that thing I was telling you about, how you can turn this bad boy around. You have to file this motion to compel. It's a pain in the neck. And you've had to write this letter and you're putting all this time in. The lawyer on the other side is making you do this for his billables and short-term fun and games. Guess what? And I see this all the time. It is fantastic. Because they made you go in front of the judge in your mini trial of a motion to compel, it's a free shot at the judge to go, here's my case, here's why, and now they're arguing, and now you get to say your theme and your meme. It's a free shot. So the bonehead billable litigator thinks short term, you long term are thinking, oh, this is another shot to argue my case in writing and in words and keep boom, boom, boom. By the time this thing ever gets to a motion for summary disposition, which is your biggest fear, judge is already in his head or her head about what your theme is, and then your motion response will just carry on the theme and meme, which came from day 1, which is your counter affidavit. So bonus tips. So you can turn around that billable bonehead. Oh yeah? I'm putting this in front of a judge. Now they have to respond. And by the way, how a litigator or a law firm or a debt collector responds to your request, again, be specific. And then their requests will tell you, give you hints on their case and what they're scared of. If they really come hard on some things where they just won't give it up, that's where you win the case. It's all about the responses, baby. Remember, I use this analogy. U.S. submarine is in the water and it sees a big mass, so it sends out a ping. Is it a whale? Is it a school of fish? Or is it a Russian submarine getting close? You send out the ping and it's all about the response. So if they come hard on certain things, because you did a good job with your focused questions, now you got free reasons to believe that they're scared. So that's why, again, a 22 approach is good, because the responses will only be specific to your questions that weirds them out. So focus on that. So that's bonus tip number 1. Look for the reactions to your discovery quests, which are thought out discovery 22-like questions. Again, that all emanates from your counter affidavit. Number 2, I have a solid video, how to take a deposition and also how to defend a deposition. 2, I'll put them both up. And they are solid. It's under 30 minutes. The one's really good. I go through it every once in a while. It will break down how to protect yourself, and the other video will show you how to do a deposition. They're all centered on the same thing, which is keep it simple, stupid. Keep your story out. Just focus on what you need to hear, depending on if you're defending or going after someone. But it's all the same advice. Keep it simple. Have a theme. Meme and theme it. We're going to bring this to an end. I don't know if it's 30 more or less, but 30 years, 30 minutes. I try. I'll put the show notes on my website, Podcast Plus. I'll put motions to compel, discovery requests, letters I send out before the motions to compel. Deposition notices are already on there. I thank you again for your time. I hope I'm helping you. This wasn't so boring. There's some I go in and go, oh, this is going to suck. This is pretty good advice as I'm reading this. I write notes for you before I do this. I don't just wake up. I do just wake up and do this stuff, but I've written. So those show notes are on my website so you don't have to look at this face again. And go up and go get them. Meme theme. Please subscribe. Comment. I do videos based on your comments. And just like this thing and love the advice. It's free. All right, go get them. I thank you very much for your time.